Hello everyone, my name is Hafiz Nayyar Abbas. In this brief presentation, I will be explaining what is injury in fact means in data breach lawsuits. We will also look at why some plaintiffs win standing in court and what companies and government agencies are legally required to do after a breach. I will be using real cases, legal definitions, and current academic reference to support each point. What is injury in fact? Injury in fact is a requirement under Article 3 of US Constitution. To sue in federal court. Plaintiffs must show they have been harmed in a concrete, particularized way. This means the injury can't be hypothetical or general. It has to be personal and real. Next slide. One of the most cited cases in Claridge versus RockYou Inc. from 2011, the company failed to secure its user database and plaintiffs claim harm from the risk of future identity theft and loss of control over personal data. While the injury was minor, the court still found it concrete enough to grant standing. Next slide. Courts are most likely to grant standing if the harm includes financial losses like stolen credit card use, the cost of credit monitoring, even non-financial harm like emotional distress or a lost time can count if it's clearly documented. Some courts are recognize personal data as a property, so if it's stolen, it's like someone stole your stuff. Next slide. But not all cases are successful. In Reilly versus Ceridian, like companies was hacked, but plaintiffs could not prove that their data has actually been misused. The court said potential future harm was too hypothetical and dismissed the case. This shows the importance of concrete evidence when using after a data breach. After a breach, companies and agencies must follow federal and a state law. This includes notifying people whose data was compromised, conducting an internal investigation, and often reporting to regulators like the Federal Trade Commission. Many companies also provide credit monitoring or identity theft protection as a legal and ethical obligation. Next slide. There is no single law for all breaches, but several regulations apply depending on the industries. HIPAA covers healthcare, the GLBA covers bank, and the state's law like CCPA in California gives consumers specific rights. The FTC can also punish companies for unfair or deceptive prac- practices if they fail to secure data properly. These are the reference I use in this presentation, including two important court cases and several academic articles. They help explain how injury in fact works in a data breach lawsuits and what responsibilities organizations have after a breach. Thank you, and this is Hafiz Nayyar Abbas.